I'm Bob Riley, and I have the pleasure of being the current chair of the Negligence Law Sections Council. The council has invested considerable time and energy in today's seminar.
32.
I would, at the outset, thank all of the participants today for the detailed work that they've provided in organizing the topics which are before you. I'd like to make a few initial remarks about the negligence section, its mission, and its work, because it gives context to that which we're doing today. The negligence section has an overriding commitment in its mission statement to excellence in the legal profession, to the preservation of jury trial rights, and to making sure that integrity in the work we do is a profound and important benchmark for the lawyers that practice in Michigan. Today's seminar is part of that effort. One of the questions we're asked is, how and why do we get involved in particular issues? And I think that's an important issue to share with you as this particular presentation gets underway. Several years ago, questions emerged regarding case evaluation, its future, its strengths, its weaknesses, etc. And the State Court Administrator's Office organized in effect, a committee broader than most with representatives throughout the state of Michigan. Among the members were a variety of individuals from both the plaintiff's side and the defense side who participated in the committee's work, which ultimately generated a series of recommendations to the Supreme Court. This section viewed that as an important contribution to the profession and became actively involved. When those recommendations were published, the Negligence Law Section Executive Council met and conferred as to whether support or rejection of those state Supreme Court or Supreme Court Administrative Office recommendations should be approved. And in doing the approval process, serious debate about our mission and the goals and objectives that we had for the profession were discussed at length. Ultimately, the council, by unanimous vote, supported SCAO's recommendations, and with that recommendation, circulated that to the Supreme Court. In addition, several members of the council appeared during public comment and shared their various insights with the Supreme Court as they were deliberating. You should know that the contributions were balanced between those who do defense work, those who do plaintiff's work, as well as individuals who are viewed as mediators. This was ultimately addressed by the Supreme Court in December with the new rules, and that's why we're here today, to share our insights into the new rule, what it means, how we believe it may be applied, and to provide general guidance. As you will note from our agenda, the second half of this presentation, once we complete the case evaluation topic, we'll move to more traditional issues of discovery and the court rules which impact it. As I've indicated, we have an outstanding panel and look forward to their remarks as we go forward this afternoon. I have a couple of brief comments beyond that. The section's activities go far beyond that which we're doing today. And what I would do is advise you, we have upcoming programming that's worth noting. On February 21 and 22, we have a continuing Young Lawyers Trial Skills program, and that will occur on both Monday and Tuesday of that week. We also, in addition, have a civility program that is set for March 24. It's entitled Civility Matters. And it is a program designed to address a compelling need in our profession right now, which is civility among lawyers and the judiciary. We think it's important, and that's a new topic that we're beginning to emphasize in our work. In addition to that March program, we have programs in April. As many of you know, we partner with ICL for a no-fault seminar on April 28th and 29th. The no-fault area, of course, is a major concern to a wide sector of the negligence law section. And if you're interested and it applies to your practice area, we welcome your attendance. On April 22, the week before that, and I forgot to mention this in chronologic order, we'll be in Nashville. And we have an educational program while we're on the road. We welcome you to join us in Nashville for a combination of networking, educational programming, and hopefully a departure from the snow and winter that we're facing today. We move forward with additional programming that will take place. I would note July 11th and 12th, which is another Young Lawyers Trial Skills program. That one is specifically focused on facilitated mediation. Finally, I would note that there's another Young Lawyers program on October 3 and 4. That one's devoted to deposition skills. The last program of our year is our big one at the MSU Troy Educational Center, October 27th, and that will be a broad program regarding a variety of issues put together by Chad Engelhardt, who serves as our vice chair of the negligence section and has a hand in all of the programming, which I just referenced. Again, we'll repeat this at the close of the program, but want to make certain that those who are interested have access to the programming that this very busy council has assembled and put together for your use. Without further ado, I'm going to turn the matters that we have for you today over to Deb Fried, who will moderate the program relative to case evaluation. Let me tell you that Deb is an exceptional lawyer who's put a lot of time and energy into this program, and we applaud that which she's done in organizing this presentation with her fellow panel members for your benefit. Thanks for your participation. Feel free to collect your questions, your concerns, and share them with the panel as they speak today, and hopefully we'll be able to address your concerns. Thanks. Deb, it's all yours.
Thanks, Bob. Good afternoon, everybody. I'm very honored to be the moderator of the first section here on ADR amendments. I am going to remind you to follow up on what Bob just said. If you would be so kind as to put any questions you might have in the chat, then the panelists will deal with the questions at the end of the program. Okay, so my part here is to get started with a very brief follow-up on what Bob explained about the history, and then to move into the general ADR and the panel. As you heard Bob describe, we had actually a case evaluation court rules committee. That followed, however, years of studies that had been done, first in 2011, then in 2018. Justice Kavanaugh, in her concurrence in the administrative order, identifies those studies. And in the email that you were provided as a handout, there is a site for you to take you to the last study in 2018, which was effectively in favor of changing case evaluation in particular. When the court came in and adopted the change in December, of course, after public comment, what Justice Kavanaugh does in that order, in her concurrence rather, is she identifies some of the primary reasons that this changed, including the idea that eliminating sanctions would level the playing field, and maybe more importantly, minimize the concept of settling or being compelled to settle a case based on a fear of sanctions as opposed to the merits of the claim, and how that played out and affected the right to trial for litigants. They mentioned also that other states do not include in any sort of case eval sanctions, and that there may or may not be dramatic impact given the number or percentage of cases that actually go to trial. Regardless, the amendment was adopted, and as Bob said, is effective January 1, 22. The first panel, who I will be very honored to introduce, will talk about whether or not there are problems with statutes that call for case evaluation and whether the conflict presents an issue for implementation of the rule, and also how the rule itself may be applied to cases that are currently pending, as opposed to cases that will be filed after January 1, 22. So not only does the handout or the email that you received, which is also in the chat, by the way, show the study from 2018, it also has the link to the administrative order. You can see that easily by pulling that up. So let me now introduce, if I might, the panel. And I will say I'm going to be fairly brief. First of all, I believe most people know the members of the panel. And second of all, we have a lot to cover. So I can tell you that I'm joined by three very experienced and exceptionally talented litigators to discuss this first ADR issue. Donna McKenzie is a partner in the firm of Olsman, McKenzie, Peacock, and Wallace, and the Negligence Council's treasurer this year. Donna devotes the majority of her practice to representing individuals who are injured by nursing home malpractice and medical malpractice. Deborah Lujan is a shareholder in the firm of Collins, Einhorn, Farrell, PC, and a member of the Negligence Council. Deb handles litigation in the areas of general negligence, professional and municipal liability, employment law, and automobile negligence. Mark Gilchrist is a shareholder in the firm of Smith, Hoey, Rice, and Rogie in their Grand Rapids office and a member of the council this year. Mark represents and defends lawyers, physicians, accountants, engineers, hospitals, and others against allegations of malpractice, professional negligence, ethical violations, and those sorts of things. And Bob Riley has graciously agreed to stay and be a part of the first panel as well. And Bob, of course, is a partner in Riley and Hurley and a preeminent mediator and arbitrator. So I'm going to welcome the panel. I am going to start by just laying out myself the primary revisions, or what we think of here as the central revisions to the ADR, specifically case evaluation 2403. We're going to cover offer of judgment with Mark at the conclusion of the 2403 discussion. So the most important, or what we think of as the most important changes to the case evaluation rule, which became effective January 1, 22, is the concept that case evaluation is no longer mandatory. Again, the link has the handout that gives you those two sections of the rule 2.403A and, excuse me, 1 and 2. And in there, you will see the language that says a court may submit to case evaluation a civil action unless the parties stipulate. And we'll have some discussion about what that means and whether or not the court still has the right to subject a case to case evaluation regardless of the stipulation of the parties. There was a change in the rule with respect to the selection of an alternative to case evaluation and the timing of that. Again, you can see in the handout that we're referring specifically to 2.403.2, where, and it gives the alternatives about whether or not a discovery plan is being filed, in which case the ADR should be included there, and where a no discovery plan is being filed, you have the right to submit to the court within 120 days of the first responsive pleading the alternative to case evaluation. The third important change is, and perhaps one that's most important to this group, is the elimination of sanctions. So subsection O was entirely eliminated in the amendment. Last, there is an update just as to practice. You must submit your case evaluation summaries at least 7 days before the evaluation, but the late fees are substantially increased. If you're within that parameter, you have an additional $150. And if you're within 24 hours of the hearing, there is a second assessment of $150. There are other changes relative to the qualifications for a neutral, and when the panel must get their opinion out. But realistically, these are the most important issues in case evaluation. So we wanted to talk first about the thoughts with respect to whether or not these court rule changes to 2403 apply to all cases, or whether torts and malpractice, medical malpractice cases are somehow separated from the impact of the amendment because of statutory enactments that effectively call for those types of cases to be case evaluated. Again, the handout has the statutory sections. And so we want to talk about the considerations, and I'm going to look to my panelists to help do that. So Donna, if you wanted to perhaps start with the rule, and we can go from there.
Yeah, thank you, Deb. The statutes that Deb just mentioned, the statutes that require case evaluation in tort and medical malpractice cases, have been in place for a very long time. The consideration that we have to look to is whether or not the statute is in conflict with a court rule. Because if we have a statute in conflict with a court rule, then we have to look to see, is the statute and court rule, are they addressing something procedural, or are they addressing something substantive? And Michigan Court Rule 1.104 specifically says that rules of practice set forth in any statute, if not in conflict with any of these rules, are effective until superseded by rules adopted by the Supreme Court. So where we've had a statute that required case evaluation, or I'm sorry, where we have a statute that now does not require, getting these confused. We have a statute that requires case eval and a court rule that makes it optional. We're talking about a case evaluation process. So the question is whether that process is procedural. If it's procedural, then the court rule will trump the statute.
So we can see Justice Kavanaugh's perception, at least in large part, and I'm going to talk to Deb Luca now, at page 9, where she refers to these statutes as concerning court administration. Right, Deb?
Yes, I agree. And the problem that many of us are trying to determine is that the effect of the new court rule on pending cases, and how we should counsel our clients as to how those are going to affect. So unfortunately, as we know that the statute is, there's some requirements for case evaluation, but now that you have a court rule that gives a conflicting amount, it's difficult to determine if you can tell your clients, if we go to a separate ADR, are we not then going to still be forced to go to case evaluation, or are we not going to have the effect? I think that there isn't a clear-cut answer, but I think one of our determinations has been that based upon what we're seeing, those cases that are currently pending and have not yet gone to case evaluation, we're assuming that the new court rule will go into effect. So the new rules will go into effect in tort cases as well. So if you have the case in front of you and it's not yet gone to case evaluation, even if it's currently pending and you're halfway through discovery, you want to now first get on top of it and get a discovery plan, and a plan with, if there's co-defendants and the plaintiff's attorney, as to an alternative to case evaluation, if that's what you choose to do.
Right.
Otherwise, you will be going to case evaluation, and it may be going to case evaluation, but sanctions may not apply. It'll be under the new rule.
So as we kind of talk about whether or not we have a concern with these, what we may call conflicting statutes, which call for case eval, and the court rule now that no longer calls for case eval, Justice Kavanaugh looked at that, because one of the concerns that was expressed by the dissenting Justice Viviano was that there was this conflict, or maybe a conflict between the statutes calling for case eval and the new amended rule. So Justice Kavanaugh talks about the fact that if a statute concerns court administration, that's her phrasing, they yield to the court rules. And she cites a case in her concurrence, McDougall versus Shands, which is a Michigan Supreme Court case from '99. There's a definition in there about when is a statute procedural, and the quote that we have here is that it takes the day-to-day procedural operations of the courts. And there's an oppositional characterization of something that is not procedural as a legislatively declared principle of public policy. So in looking at whether the statutes that conflict and call for case eval with sanctions, in deciding whether or not to argue they are procedural or not, you have to think about whether or not they are articulating a legislative declared principle of public policy, or whether they are simply dealing with the day-to-day procedural operations of the court. That's going to be a primary focus on trying to assess whether or not the statutes create a problem if you do not want, number one, to be compelled to go to case eval, number two, to have sanctions. So the other issue that comes up, and maybe Bob can talk about this, is even if the statute's sanction provisions are procedural, once, and as Donna mentioned, there's a court rule that's right on point. If it is a conflict and it's procedural, the court rules win. But if it's procedural and now we have a court rule 2403 with no sanctions, is there a conflict? Is there a conflict where the statutes say sanctions apply, the court rule is silent on sanctions? That's another consideration that Justice Viviano brought up. So, Bob, do you think that the silence alone means that there's no conflict, or can we see that the clear elimination of sanctions is still an inherent conflict?
Well, this is opinion only, so put it in that
I'm good with
context. It seems to me that the process by which sanctions are determined is process subject to the court rules. And the process by which sanctions occur requires a series of steps designed to demonstrate that they're appropriate in the first instance. And if one is viewing the process by which sanctions would occur in the context of a normal case, this requires verdict, assessment of the appropriateness of sanctions, a discretionary determination by a judge on the facts and merits of a particular case, and then, of course, a finding as to what the measure of sanctions would be and the process by which that is determined. I would argue and believe that the process-oriented nature of sanctions governs, and under the decisional authority of the Supreme Court, that is their bailiwick. They've determined sanctions under this process are inappropriate, and to me, that would govern. So that's how I would at least initially argue it and frame it to be consistent with the prior holdings of the Supreme Court.
I think it's also important to point out that in order to get to the question of sanctions, you have to case evaluate first. And if case evaluation is procedural, which I think is something we can all agree on, if the case evaluation process is procedural and it's optional under the court rules and the court rules govern, if you never get to case evaluation, you never get to those sanction issues.
However, If you choose to go to case evaluation, so there are some cases that case evaluation may be your best option or an option that you want. A way to sort of make sure we're all on the same page, the plaintiff, the defendant, the co-defendants, as to what is applying, is a stipulation that you are going to case evaluation, say a case is filed before January 1st, 2022, that the new court rules do apply. So you'll all know when you're accepting, rejecting, dealing with case evaluation, that it's case evaluation, but there are no sanctions.
So let me ask this though. I mean, is there an argument that you can call out of the statute? All right, let me back up. We know that the statutes have procedure right in them. I mean, I think it's fair to say that when it talks about referring a case to case eval within 91 days, that's procedure, right? But as a part of those statutes that require case eval, there is sanctions provisions, right? So can you call out the sanctions provisions in the statutes and then argue, and then have the problem that you've got a statutory sanction that is substantive in light that would presumably carry the day over a procedural court rule? I mean, is that going to be something we're going to be confronting as plaintiffs and defendants as we go forward?
Well,
I think that there's an argument, but I think it's probably less persuasive than the arguments that you know, our panelists are discussing. And you know, probably the best in my mind, and to echo what Bob said, this is opinion only because it's all uncharted territory at the moment, but it would seem to me that if you're trying, whatever side you're on, and you're trying to prevent sanctions from applying, the best and most simple and straightforward argument is, well, Judge, look what the Supreme Court did. We had a sanctions provision that was clearly erased. So we know what the Supreme Court thinks about that issue. And, you know, if your opposing party comes back with, well, there's these statutes and they allow for sanctions, I still think the more persuasive argument, when we're all, of course, attempting to interpret what the Michigan Supreme Court wants us to do, is based on what they've very recently done, sanctions shouldn't apply.
So is this a concern? I mean, is this a real concern in practice? In other words, how many of you have actually had a case ever referred for mediation or case eval under the statute, either the tort statute or the Med-Mal statute, as opposed to just getting a notice that pursuant to 2403, you're going to appear for a case eval? Has anybody had a case referred under the statute?
So Deb, I can
can't think of
answer
one.
that in part. I have had two cases where I have served as mediator where case evaluation sanctions became an element of the negotiations, one of which was today, this morning. So this is not a fully resolved issue. The argument was made that the settlement value of the case presumptively involved a victory for that party, and that sanctions would apply and should be factored in to the negotiation. Now, that's a lot of assumptions, but the point being, the arguments to support that, although not framed for me today, likely could take the very course we're talking about.
Did anybody else want to comment? Thanks, Bob. Okay, so Bob, you've done this forever, and you had two cases where this has been an issue. And we're going to talk now, I think, we're going to move into the concept that I think people are particularly interested in, given that we don't often see statutorily referred case evaluation. And that is whether or not the court rule, the change effective January 1, applies to pending actions. And in particular, we'll cover both of these, but whether it applies to actions where there has been a case evaluation already, as opposed to one that is upcoming. So there is a court rule that is, again, in the link as a part of those materials. It's 102. And I'll just read it because I think it's actually important in this. These rules take effect March 185. They govern all proceedings in actions brought on or after that date, and all further proceedings in actions then pending. A court may permit a pending action to proceed under the former rules if it finds that the application of these rules to that action would not be feasible or would work an injustice. So I'd like the panel to talk about the considerations about whether or not, in their view, the current amendment is likely to be applied in cases that are pending, that were pending before January 1, where there was a case eval previously. And we did also include, again, for your use, some citations to various cases that may be helpful in deciding or in reaching a conclusion on this question. So I mean, if we want to take a shot at this, Donna, go ahead.
Sure. So I think the big question is going to turn on not necessarily when the case was filed, but when case evaluation occurs, and maybe not even when case evaluation occurs, but when the parties accept or reject the award. Because I think the courts have recognized in a number of cases over the years that if the change would work an injustice to apply the new changed rule, then the old rule is going to apply. So we've got that, for example, the Dressel House case was a case where the court determined that the court rule that was in effect at the time the plaintiff rejected the mediation evaluation was going to be the court rule that applied, because otherwise it would work an injustice. So I think we've got, obviously cases filed after January 1, 2022. I don't think this is an issue. It's going to be those cases filed before January 2022, and it's going to depend on whether case eval had already occurred or not, and whether or not there had been an acceptance and rejection period, and the parties had made decisions and strategic decisions based on whether or not they thought sanctions would apply at that time.
Right. I think I would tend to agree with that, frankly. I think too, there is a discussion of how to utilize this, the concept of injustice or working in injustice, if that becomes an issue in, I think it's Wright. Sorry. Yes, Wright Meyer. So, which is also in your materials. Well, what do you think? Let's assume you have a case eval that's already occurred, right? The case was pending before the case eval has occurred. The rejection or acceptance was made, but the case isn't over. So people don't know whether or not it's actually going to have an impact. Do you think counsel can enter into an agreement, a stipulation, for example, that the sanctions, that there will be no case evaluation sanctions? Deb?
I think some of that is going to depend on your judge in allowing you to do it. But if that is the desire of both and all parties involved, if you put that in front of the court, then I think it's going to be hard for the court to turn that down. I think that the general rule, the backup rule, is going to be that the court rule that was in existence at the time acceptance rejection occurred is going to be the one that's going to take precedent over whether there's sanctions or not. And because that's what was relied upon when they accepted or rejected the award. But I think you're going to have some judges that say, no, sanctions are something that you all knew at the time you accepted or rejected. And because I have the power, it's up to me to determine whether or not there's going to be sanctions that apply, and use that for negotiating. And that is one of the things that I think we wanted to bring to everyone's attention, that as an attorney, you have got to counsel your clients as to the what ifs of how this is going to play out, and that the rule is silent. So when you're sending your letters about what's happening with case evaluation, we're assuming cases that were filed before the first of the year would still, but has not yet been evaluated, the new rule would apply. But I don't think that we can say that absolutely, because the rule is silent as to that. And so then it's some of your attorney judgment rule as to exactly how you counsel your clients, because you want to make sure that they're aware that there is that, I guess that silence that isn't an absolute, which we're part of the panel of what we're trying to do is to get some clarification on that, so we all do know what the ground rules are on accepting or rejecting.
I think that the Ligon's case also has something to say about that concept that might be helpful in bringing some clarity, because that case, that was a malpractice case. It dealt with affidavits of merit, and there was a whole discussion about statutory issues and court rule issues. But for purposes of this discussion that we're having right now, that there was an amendment to the court rule in that case. And in that amendment, it said it was effective then May 1 of 10, just like this one says it's effective January 1, 22. And the Supreme Court, although again, they weren't analyzing the specific issue we are now directly, but they said because the court explicitly ordered that the amended rules have prospective effect. So the mere fact of making the rule, quote, effective, the Supreme Court said in that case that meant it had prospective effect. So if you have what is the panel's view about whether or not the court can continue to order case eval?
Can I mention something before we get there, Deb?
Yeah, and I wanted to as well, Don. I have to.
Yeah, absolutely, absolutely. I'm so sorry. Chime in anytime.
You know, given the reason why these changes were made, specifically that the Supreme Court, did not believe that sanctions offer a level playing field for all parties, and that sanctions force settlements that are not based on the merits of the case. They're not used by other states. They're no longer needed in a state like ours, where less than 1% of cases actually go to trial. I think of those reasons, probably the biggest one is the unlevel playing field. But I do think there is an argument to be made that even if there was an acceptance and rejection of case evaluation that already happened, I think there's an argument to be made that they shouldn't be implemented.
Based on the rationales for the change in the case evaluation rule.
Correct.
Yeah. Mark, what was your comment?
Sure. We touched on it, but I think it deserves highlighting. Deb, you mentioned the Wright case, and of all the cases that we provided to the attendees, I thought that case sort of put the most meat on the bones in terms of what's working in injustice, because that can be a little ambiguous and really in the eye of the beholder. But and Deb Lujan had mentioned this, but if an injustice works when one of the parties relies upon, takes action or inaction, depending upon what the old rule was, in this case evaluation with sanctions, then that is an occasion where injustice occurs. So to me, the concept of reliance made the most sense. So and again, in my mind, that's the best argument. Donna had just mentioned contrary, but if the acceptance rejection date has already occurred, before 1/1/22, then one of the parties has relied upon the old court rule, maybe both, but certainly the prevailing party is going to have relied upon the old court rule. And so if we take the language from Wright in terms of defining what a working injustice is, to me, that pointed us in the right direction.
You know, and that's, I mean, these are obviously both exceptionally well thought out points. And that's the problem right now. They're both exceptionally well thought out points. I will say that is there an issue about this reliance? You know, Donna is talking about the purpose of the change. And Mark, you're talking about the fact that there was a reliance on maybe a sanction, as opposed to, in other words, is that enough? Is the fact that, you know, you're relying that maybe there'll be a sanction enough to create that injustice in light of the fact that the court is actually saying we're changing the rule because it works an injustice? So, know what I'm saying?
I know exactly what you're saying, and that's the rub.
Well, I think that we're going to find that in different situations, we're all going to argue something a little bit different. So it's going to be interesting if when these things start to play out, and whichever receiving end you're on, which way you're going to try to argue it. But I think an argument can be made both ways. But when the acceptance was, when the consideration was made, when you determined whether or not this was, maybe if as a defendant, it was more than you wanted to pay, but it wasn't worth risking sanctions, or as a plaintiff, it wasn't what you wanted, but it wasn't worth risking sanctions because of the 10% rule. If I don't better my position by 10% or more, then I'm risking. And if you're a plaintiff, you may get something, but it may be reduced by the attorney fees that have gone into the case since acceptance rejection. And as we all know, with what's happened in the world in the last 2 years, there may be cases that are sitting out there that have nothing's happened, but maybe a lot of attorney fees have gone into additional things because we haven't been able to go to trial. So case evaluation may have been a year and a half ago, and you've incurred additional attorney's fees or whatever, either side. So that is something that you say under the old court rules, I am entitled to my attorney fees and sanctions and costs. And that is something, depending on if you accept it and you are in that position, or if you reject it and you're worried about it, that's something you, like I said, you better consider to counsel your clients on. So, you know, it's funny because as plaintiff and defendants on this bar, it's very interesting. We all think on leveling the playing field. You know, as defendants, they say, well, it's not fair to us. We have a number and we would end up paying sanctions, so we may accept that number. As a plaintiff, they worried because, you know, if they don't overcome that 10%, their verdict, if any, could be, or they end up owing costs. So there is the consideration as to what we used to counsel our clients on as to why case evaluation sometimes felt like a forced settlement because of that sanction provision.
So I think the argument ultimately is, how does 1102 play into this decision? Whether, meaning all further proceedings, even if you had a case eval before, how the case law that's come down so far plays into this decision. And frankly, I think as you read those cases, some of them are, they don't analyze it in depth, let's put it that way. And the third thing is the idea about injustice given what you did versus the sense of injustice with maintaining sanctions. So it's going to be very interesting as we go. I do think there is case law that we should be looking at. It's provided to the attendees to help them along that path. What's the panel's opinion about whether or not the court, and I know we have judges with us, and I welcome everyone. I'm still going to ask the panel this question about whether or not, do you believe that the court retains the ability to order case evaluation where the parties have stipulated not to have case eval? Jump in, anyone.
I think that you should not be surprised, even if you have tried other methods of getting a case resolved and you went to facilitation or mediation, whatever term you like, and you were unable to resolve it, and then you're in front of a judge for a settlement conference. I don't think you should be completely surprised if they say, well, if that didn't work, maybe you should try case evaluation, because it still is a method by which three people put a number on a case that they have to consider, and then the court feels like they have a number that they can talk to both sides about to say, this is what three attorneys placed on your case. Why is this not what you need, or why is this not a good number, even without the sanction provision? So I think that courts are still going to have that as a, I'm not ready to give you, or I can't give you a trial date right now, and I'm going to make you go through that method if they've been unsuccessful in other means of resolution.
And if you look at Justice Kavanaugh's concurrence attached to the order, it appears to me like that she believes judges can do that. And I'll just quote her language. Judges retain authority to accept or reject the party's stipulation to waive case evaluation. So I suppose you'd have a better case if the judge initially accepted it, and then in Deb's scenario, well, we've done all we can, but trial's still forever because of the backlog. I changed my mind, and why don't we give case evaluation a shot? That could happen, certainly. I mean, is it written in the rule? Probably not, but could it happen? Absolutely.
Yeah, and I think that part of the key of what Deb pointed out is that, a judge might do that after you have tried the ADR process that you've selected and stipulated to, because the court rule does say that a court may submit the case-to-case evaluation unless the parties stipulate to an ADR process. So I think we'll probably be seeing that in situations where the process that was selected isn't a successful process, and you go back to the court, and the court might say, well, now you have to try this.
See, the thing that's so interesting about that is that as a part of 2.403A, again, following up on what you just said, Donna, the next sentence is parties who participate in a stipulated ADR process approved by the court may not subsequently be ordered to participate in case eval without their written consent.
Yep, that strike everything I just said.
I actually think that what you just said is true. I think we're going to see that. And I think what Deb's point again was the court feels, may want to do that as another effort to resolve. And, we may very well see that. It's just interesting. And Mark is right about Justice Kavanaugh's comment. So it's interesting that we're seeing those things despite what the rule says. So
if that does happen and case evaluation is ordered late, it would certainly seem to me, though, that sanctions should not apply. I mean, that, in my mind, at least, is clear.
Right. I think everybody.
I don't think this is that unusual in the fact that courts have always had the authority. You can come in and they'll say, one, go back to facilitation, which you pay for, or if a case evaluates less than 25,000, go see, there's a mediation process you have to go through, or I'm going to come bring you in for a facilitation day and you better have your people available for discussions. So courts retain that jurisdiction to do that. I mean, the change is going to be that they may not have the hammer of the sanctions, but they may use the case evaluation process to get the parties to come closer, to give at least a number that the judges can work with, because they're not going to have, they may not have that, depending on whether the parties share that with them as to what the result of their ADR was.
I can add at least some comment to this based on what I'm watching and observing. There's two options that exist for meeting the goal or objective of a number that the parties should consider. And while sanctions are removed, the offer of judgment rule is still in effect and is a vehicle with which the parties can control their own destiny regarding numbers and shape potential resolutions. Again, it's not the same as case evaluation, but it's a technique still left in the rules that's been endorsed to some extent as a substitute for sanctions as we know them. A better approach, however, is emerging, I think, and I'm now seeing orders come from courts that the parties shall get a mediator's proposal, which is not case evaluation, but designed to start reflecting what the negotiation process revealed, and that the individual who's assigned mediation responsibilities is to supplement that when things break down with some type of recommendation or proposal. So there are ways for the parties and the courts to work together short of case evaluation with options, but simultaneously preserving the ability to generate a number with which the parties have a target for potential resolution. Again, not a perfect solution, but a substitute. And I would suggest that the numbers we saw on case evaluation, acceptance, rejection, which hover in the 13 to 14% range, are miles apart from the mediator proposal option, which I would say has a greater than 50% chance of resolving cases, in large measure because it avoids the public disclosure of parties' acceptance and rejection and allows parties to anonymously accept without penalty if the other party rejects and they accept. So there are desirable options emerging that are at least a substitute. They don't answer the past and its dilemmas, but I think they offer options in the future.
I also think the options that this new order, the new court rule gives us is control over your case. It forces you to look at your case and determine what's the best method of possible resolution by coming up with a plan with your co-defendants, with the plaintiff, as to how to get you there, because case evaluation didn't get you things that defendants need, which is a release of all parties, confidentiality, non-disclosure, non-disparage, things like that clients want, maybe on both sides, or if they're things that are non-monetary. So it gives you the control. So I think we're using a lot of cliches. I love cliches. So cautiously optimistic that we now have more control, but you have to be smart. You have to look at it and get an order in front of the court quickly to show the court. We're looking at this case. We're trying to determine what's best for us and coming up with a plan that will get us to a possible resolution after we've determined what the issues are. And you can do it in stages. You can say, I need these 3 steps, and then I'm going to have a case eval or a facilitation, and then go stage 2 if you're unable to do it. So it gives you a lot more control than the old system gave us, where we just waited around for a case evaluation notice.
So even for cases that were pending before January 1, 22, even for cases where a case evaluation has occurred, but certainly in cases where it hasn't yet occurred but again, cases filed before, the recommendation sounds like from the panel, talk to your opposing counsel, get, if you can, an agreement, follow the court rules, obviously, if you're talking about first responsive, et cetera, but get an agreement, try to figure out whether or not you want the case eval, you don't want case eval. If you had case eval, whether or not you can confirm or agree that sanctions won't apply, whether you want to enter into another ADR process, but attempt to do this directly and in writing, and advise clients of the lack of clarity in this area. Is that basically the gist of what we're saying about the changes for cases prior to January 1, 22?
Yeah. And when if you determine that case eval is your best option, because you don't pay a mediator, it's then determining how to go about it and making sure that your clients are aware, and hopefully everyone agrees that even though that's a case evaluation award, you won't have the sanctions as a hammer either way.
So let me come back to that in just a second, Deb, because I think those are excellent points. We can talk about when we might want case eval, whether we have sanctions or not. But what do you think about the possibility that specific counties, there was certainly pushback by some of the judiciary to the change in the rule, particularly the elimination of sanctions. there is a court rule and a statute, I think, that may help and people should be aware of if there was an effort by counties, for example, to attempt to enact a local rule resurrecting case eval, especially with sanctions. And that, I think that's in the materials as well. Rule 8.112 indicates that as far as local court rules, a trial court may not adopt rules regulating practice if the rules, a trial court may adopt rules regulating practice if the rules are not in conflict with these rules and regulate matters not covered by these rules. There's also a statute 600.621, at least for circuit courts, that says the circuit courts from time to time may make rules for regulating the practice of said courts in matters not covered by rule of the Supreme Court or by statute. So is there anyone on the panel who thinks that the various counties could change and revisit, so to speak, case evaluation with sanctions by local rule?
I think it would be pretty difficult to do because I think the local rules would have to be adopted by the Supreme Court, and the Supreme Court has already given its opinion on this issue, which is that case evaluation is not an effective or efficient process, and it is not a fair process. So I think it would be hard to get that local rule passed, but that's just my opinion.
Anybody have a different opinion on that? Okay. Okay, so kind of returning to what Deb was talking about, certainly there are cases, or there may be cases, even going forward, that should be submitted to case eval or shouldn't be submitted to case eval. There are some considerations that I think the panel can suggest to think about in formulating your discovery plan, or just deciding whether or not to stip to case eval or some alternative ADR process as you go forward in circuit court, or even it can apply in district court. So why don't we talk about what some cases where you might want case eval and some where you might not, and you might choose something else.
Well, I think a lot is going to depend on the complexity of the case and sometimes the value of the case, and if it's just monetary that you're looking for. But I think there's even ways that you can use the case evaluation process to your advantage, where if that is the better alternative for you because the case doesn't warrant a half-day facilitation and the cost of that, or whatever you determine with your client, you can still send out, try to get an agreement that if the issue is I don't get a release, that we'll agree to go forward with case evaluation with the understanding that this will be the release. Obviously plug in the number if that's accepted, so that you get ahead of it, because obviously part of the problem with case evaluation was you didn't get a release. Most of the time you can talk your opposing counsel into a stip and order or dismissal, but they didn't have to give it to you. They didn't have to give you a release. They had to just give you the judgment, and you had to pay within a certain amount of time. So, again, this rule helps us to realize that we're going to fight enough as plaintiff and defendant over, issues involving the case, but setting forth the method to try to get the parties to come together and get the case resolved. Work out those issues, determine if the release isn't acceptable or whatever ahead of time, so that it's not something you would have an issue with if the number is right. So if those are the things that you can work out ahead of time, case evaluation might be the way to go. It may be what's all that's needed for your case, and the numbers, you plug it in and you get the case resolved. That's still an option.
So from the defense perspective, if things like a release and non-disclosure, similar sorts of provisions are imperative, then unless you can get an agreement from opposing counsel, you might not do case eval. You might try to avoid case eval.
Yeah, because I think the new rule is as of the old rule. It doesn't give you anything other than a number accept or reject within your time period, and that still is the same. The sanctions is really the big issue that was removed.
So from a plaintiff's perspective, Donna, any thoughts on why you might want case eval or not, given going forward, given that there are no sanctions anyway?
I definitely think that there may be situations where case evaluation might be helpful. I have a case right now where we're talking about setting up like a blue ribbon panel. And obviously, in situations like this, you have a little bit more control over who is sitting on the panel. You can make sure that the people who are sitting on the panel are familiar with the area of the law, are familiar with the issues in your case, have tried cases before, are familiar with the jurisdiction. Because I think that was one of the big factors in why we were seeing a case evaluation process that was ineffective and inefficient. It's kind of like almost like a mini arbitration, except it's not binding, but I think it's going to help in this particular case, the parties moving forward. I don't think this is something that is probably effective or efficient in every case, but I do think there are the cases out there where it might be helpful.
Okay, great. Bob, in your experience, what have you seen? What would you suggest might be, because you see from both sides, plaintiff and defense, are there any additional thoughts that you would have about why we would want case eval, why we wouldn't want case eval going forward under assuming the new rule applies, no sanctions?
That's a really good question. I'm concerned about the assembly line process. The judges have a huge backlog typically to handle, and they really want numbers to be utilized in the process so that there is at least a target and a basis for discussions. I weigh that against the parties getting to control their own destiny. What I think really applies is planning on an individual case basis. If we don't do that, we're missing the opportunity that the rule is designed for. You have the option as to timing. You can do this early in the case. You don't need to run up your costs and expenses. You can address the process of ADR early on, minimize costs, and try to get a case moved. Correspondingly, there are cases where you need to be a year in because that's just the nature of the discovery process. That needs to be recognized. Deb hit a key point. We have to have a system that accommodates the real needs of the parties. So confidentiality, getting a release, avoiding an offer of judgment. I mean, those are key elements that prevent case evaluation from being effective. More importantly, the emerging pressure on lien holders to maximize their recovery that thwarts settlements. We need a process that recognizes that. So balancing the needs for numbers versus the needs of the parties, I would advocate that there be conscientious and thoughtful planning at the outset as to ADR needs and plug them in for the case-specific matters that you have before you.
Okay, jumping off from that point, I think I'd like Mark to talk now about offer of judgment, in fact. And I'd like to, so that we can both stay on time and cover everything that we're supposed to cover.
Sure.
So Mark, if you could do that, I'd appreciate it.
Absolutely. Yeah. Let's walk through it fairly quickly so the next group can get in. But the short answer is that the offer of judgment is about to come back into our lives in a very big way. My read on it was the teeth were effectively taken out of the offer of judgment rule on October 1st of 97, when the court rule changed and stated that there would be no more costs associated with the offer of judgment if a case was submitted to case evaluation. So, we're coming up on 25 years where certainly in almost all the cases that I've ever handled, the offer of judgment really didn't have much utility because, you know, all of my cases would, at the end of the day, get through case evaluation. And so whatever offer of judgment was hanging out there effectively was not enforceable. But again, obviously, with everything we've just discussed, the new changes to the case evaluation rules, and case evaluation will probably not happen very often, the offer of judgment comes back into play. So let me highlight a couple of things of interest before I sort of walk through an example. And these are, I'll tell you what rules have changed versus a couple that I thought were worth mentioning that remain in existence. But the first is an offer of judgment has to be filed or can be filed up to 28 days before trial. So if you're 28 days before trial, your time to file an offer of judgment has ended. The adverse party, so the non-filing party, has 21 days to accept that offer. Silence is considered a rejection. So that is similar to the current case evaluation rule as we all understand it. And a rejection doesn't preclude follow-up offer. So, you know, you can go through one machination. If that doesn't work, you can proceed forward. So let me give you an example that I sort of went through, one of mathematical ease that most of our cases won't be this convenient, but we've got a case. Let's say the defendant offers $100,000. The plaintiff counters at $200,000. What that means, and the operative number in the offer of judgment rule, is you go to the average, right? So in this case, the average is $150,000. Case goes to verdict. Jury comes back at 175. That's above the average. So the offer of judgment rule is implicated, and the defendant is on the hook for actual costs. I should also mention that when you're tabulating the verdict, so, you know, I said the jury came back at 175 for ease, but it's a little more complicated because under the rule, the verdict includes interests and taxable costs from the date of filing of the complaint. So, you know, when you're putting together the judgment, as you always do, you would include those fees into the verdict amount. So as an aside, in my example, again, 150 is the number that everyone's worried about with the numbers I've provided. Let's say the verdict came back at 145. Well, if you can get your interest and costs, excluding attorney's fees, but interest and costs above the 150, then the average is implicated and attorney's fees are on the hook. So in my scenario, the defendant is on the hook for actual costs. Those include costs and fees that are taxable in any civil case, plus reasonable attorney fees. That's a concept that we're obviously used to dealing with through the case evaluation process. Might be a fight about that, but you know, that's what the rule says, a reasonable attorney fee. Now, what's been changed, one of the new rules to 2.405, and this is A6, the timing has been drafted into the rule explicitly. So actual costs begin from the date of the rejection to the prevailing party's last offer or counteroffer. So again, it's a concept similar to what we're used to in case evaluation terms. We're going back to the last rejection date in terms of tabulating costs. There's another real important change. The existing rule was that the court could waive imposition of attorney's fees in the interest of justice. The new rule provides us, it's not a limiting rule, but it provides, these aren't the only examples, but gives us two examples of what is in the interest of justice. The first, to quote the rule, offers that are token or de minimis in the context of the case, in the interest of justice, would strike attorney fees. So I suspect, I don't know, my guess is the court's trying to eliminate any sort of gamesmanship in this regard. Terrible case, offer $10. A weaker case, ask for $5 million. So trying to eliminate that sort of dichotomy. Of course, what's token, what's de minimis hasn't been determined, but we can look forward to that in future years as that's litigated. Secondly, attorney's fees will not be provided in the interest of justice if the case involves issues of first impression or of public interest. Okay, so that's an exclusion. Lastly, with respect to changing of the new offer of judgment rule, even if a case goes to case evaluation, the offer of judgment rule still applies. So the language has been stricken in the case evaluation rules, basically indicating the case evaluation supersedes an offer of judgment. And it's also, the new offer of judgment rule has eliminated the need for a unanimous verdict. Non-unanimous verdicts used to be excluded, or non-unanimous case evaluation awards were excluded from the offer of judgment not applying. Now that's been eliminated. So again, you can think through the situation where, for all the reasons that were just discussed, maybe case evaluation is warranted. It's probably, we can all agree that even in those cases, sanctions won't apply, but the offer of judgment rule still stands, even in the event that a case has gone through the case evaluation process. So long and short of it is, for folks like me, like I said, we've come up on 25 years. I've been practicing since 2000. I've probably only used an offer of judgment 3 to 5 times. Going forward, we should all anticipate that is not going to be the case. I suspect the offer of judgment is going to be used in almost all of our cases, almost all of our tort type cases going forward. So I guess I would leave our attendees with, read the ICL section on it, read the court rule, because it's something that is going to be become much more prevalent.
So we've got 1 minute. I just want the opinions of the defense and the plaintiffs here. You believe it's going to be utilized more because there is a sanctions provision effectively? Because otherwise, why would anybody use offer of judgment?
Yeah, that would be my best guess, to impose the the teeth that were written into the case evaluation rule, certainly have always been in the offer of judgment rule, but now it applies. Yeah, to apply some pressure and try to exert some leverage over opposing party, hopefully to resolve the case, set by way of settlement.
I still think there's going to be some balancing, because again, it's an offer of judgment. So you're going to put a number out that your client, as a defendant, you're willing to have a judgment against them. So I don't think it's going to be as prevalent in some situations with clients that don't want a judgment and still need releases and the other things that we talked about earlier. But yes, there's going to be a balancing as to whether you want to try to use it to at least get a number and have the possibility of sanctions.
Donna, any thoughts on the plaintiff side?
Sorry, I couldn't find my mute button. No, I agree. I think that the issues that Deb raises with not being able to get a release and having a judgment filed against you are probably going to be pretty big detractors from using it. I know, Deb, you've had experience with this. I would love for you to share your experience because I think it's really important, but I don't know how much time we have.
I think where it's going to be used is in an effort to drive settlement. It's going to be used, to, again, try to drive the parties together with the ultimate goal of settling the case. On the defense side, of course, we always want releases. So we'd be able to get there through strategic use of the offer of judgment.
Okay. Well, I appreciate all of the panel here. I'm going to turn it over to my co-moderator, Tom, to take on the issue of the discovery rule changes and the follow-up that we've seen. Thanks so much, everybody.
Thank you.
Thank you, everyone. My name is Tom Beam, and we're going to have an opportunity now to talk about the new court rule changes. And we've got a wonderful panel with us this afternoon. Let me introduce Jenna Wright Greenman. Jenna is a member of the negligence law section for the State Bar of Michigan. Jenna is not a stranger to anybody who does litigation work across the state. She is a fantastic lawyer. She's recognized as a leading lawyer in the Leading Lawyer magazine. She's also recognized in Best Lawyers of America in the area of medical malpractice, defense. She's a member of the very prestigious Federation of Defense and Corporate Counsel, where there's a little over 1,000 members worldwide. She is also a member of the American Board of Trial Advocates. She's also been named a go-to lawyer. The list goes on and on. Jenna, we are thrilled to have you today, and we're very excited to hear your thoughts about these new court rule changes and what has come of those. We also have Jeannie Early. Jeannie is the founding member of Early Law in Grand Rapids. Certainly on the west side of the state, Jeannie is well known by many of us. And Jeannie has had an active role in MAJ. She currently serves on their executive board. She also serves on their amicus committee, which is a very powerful committee, as it provides amicus briefs to our Supreme Court and Court of Appeals. She's also a member of the National Employment Lawyers Association. Jeannie has tried a number of cases and has a great deal of trial experience. Jeannie, welcome. We're thrilled to have you as well. I think you're muted there. There you go.
Thank you very much.
Absolutely. And last but certainly not least, we have Judge Chris Yates with us. Judge Yates is a member of the Kent County Circuit Court bench, where he currently presides over the specialized business docket. Judge Yates was one of the people who was involved very heavily in these changes to the court rules. He is no stranger to the negligence law section and enjoys a wonderful reputation across the state. He is currently serving as president of the Michigan Judges Association, and we're going to want to ask him a question about the retroactivity rather of the court rule, the case evaluation change here in a minute. But he's also a member of the American College of Business Court Judges. He's past president of the Grand Rapids Bar Association. He also serves as an adjunct professor at Michigan State University Law School and Thomas M. Cooley Law School. He is a recipient of the Michigan Judges Association Hilda Gage Judicial Excellence Award, and also a recipient of the Michigan Defense Trial Council Judicial Excellence Award. We have got just a wonderful panel here. But before we talk about the court rule changes, Your Honor, I think all of us would like to know from your perspective, how does the new case evaluation rule apply? Should it be retroactively applied or not?
It's interesting how fate befalls you sometimes. And the fact that I was on both of the committees on the discovery rules and the ADR rules puts me in the awkward position of having to defend the handiwork of two different committees. But let me do the best I can. And let me preface my comments by saying that I'm offering these thoughts just in my capacity as me. I'm certainly not offering them in my capacity as president of the Michigan Judges Association, because we had an executive board meeting last week where there was a spirited discussion about retroactivity of the case evaluation amendments. So let me do the best I can trying to answer it from my perspective as if the question were presented to me as a trial court judge. The starting point of the analysis, of course, is Reitmeyer versus Schultz Equipment, 237 Mishap 332, 1999 case. And you can do the best you can to try to make sense of it, but there are a couple of basic principles from Reitmeyer that I think guide the analysis. First of all, you can't just say as a general proposition that the amendments are retroactive or they're not retroactive. You have to take a look at Michigan Court Rule 102, which the Court of Appeals in Reitmeyer says prescribes the following principles. The norm is to apply the newly adopted court rules in pending actions unless there is reason to continue applying the old rules. Okay, so the default position is if you have a pending case, you apply the new rules governing case evaluation, not the old ones. However, if there would be an injustice as a result of that, that changes the outcome. As a matter of fact, it says a new court rule would work in justice where a party acts or fails to act in reliance on the prior rules, and their party's action or inaction has consequences under the new rules that were not present under the old rules. And if I can pick up one or two more sentences, I think I can get to where I'd come out. At 237 Mishap at 340, the Reitmeyer court said the MCR 1.102 exception is more clearly defined simply because it is premised on the fundamental rule of law notion that parties should be able to rely on the rules as they exist at the time that they undertake conduct. I think that's the key. As far as I'm concerned, if you have a case that's far enough down the tracks, so there's already been a case evaluation under the old system, and there's been an award that's been accepted or rejected by one side or the other, which of course has consequences, I think you can make a strong argument in those limited circumstances where there's actually been an award that's been accepted or rejected by each side, that the sanctions provision should apply. In all other cases, though, I don't know how you could make that argument because you have to put two propositions together. First of all, subsection O has just been eliminated. It doesn't even exist anymore. And if case evaluation hasn't taken place, it seems awfully difficult to make the argument that the parties should be able to rely on the rules as they exist at the time they undertake conduct. Well, you only undertake conduct with regard to case evaluation when you engage in the case evaluation process. So although I know I have colleagues who would like to take the view that every single case filed before January 1, 2022 should be governed by the old rules, I just don't see it that way. As far as I can tell, all the cases that are midstream where case evaluation hasn't gone forward cannot go forward with the sanctions provisions in place. And in addition to that, I know there was some discussion about whether a judge can sua sponte order case evaluation and even tag sanctions on top of it. I don't see how that works at all under MCR 1.102 because 1.102 talks about the party's reliance, not the court's reliance. And so I'm sounding pro litigating attorney and anti-judge on this one, but I just don't think the judges have the room under the new court rule read in conjunction with MCR 1.102 to force a case to case evaluation if the parties don't fall under one of the categories that would send it there otherwise. And I certainly don't think a judge has the unilateral authority to dictate that sanctions apply. I know there are people in my organization who disagree with me on that, but that's my view.
Your Honor, thank you. We appreciate that. That is helpful for all of us who are practicing in those unique situations. And it's nice to have a person in your position who is kind of in both camps to give a little opinion. So we appreciate that. Mm-hmm. Let's turn now to the new court rules. I want to ask everybody on the panel, first off, how are the new court rules treating you and your clients? Jenna, how's it going?
Yeah, thanks, Tom. And thanks again to everybody for allowing me to graciously speak and be here as part of this panel and with this wonderful seminar that was put together by the council. You know, I've been very excited to talk today and to get Judge Yates and Jeannie's thoughts on this collectively, because my sense is that the new court rules, everybody had a lot of anticipation, trepidation in terms of what on the defense side and plaintiff side in terms of what was this going to do. COVID obviously got thrown in the mix. If you recall, they were going to go into effect at the beginning of January 2020. And then, you know, 2 months later, everything is shut down like the Book of Eli. That being said, I think that they've worked out well in the sense that with most of my cases, at least, and opposing counsel, there's been a lot more discussion, shall we say, right? Because now the plaintiff has the onus on the front end to reach out to the defendant if they need more time for initial disclosures, things of that nature. And at least my practice is sure, you know, and vice versa. We've had, to me, it's precipitated a lot more engagement in the cases early on, but sometimes to benefit both parties, whether it's more time, being able to supplement, things of that nature. So I've welcomed them, but welcomed them in a different way, in the sense that a lot of my cases, they have not functioned or applied in black and white as I believe the black and white intention is, if that makes sense. And I know we'll talk about some specific examples as we move forward in terms of what the rules require and, you know, how everybody has effectuated those rules or not.
From the defense standpoint, though, Jenna, you think it has encouraged communication between counsel for the parties?
I do. Look, we're all blessed to be, I think, very busy on both sides of the fence. And again, you know, it is what it is. It's reality in terms of with COVID and the backlogs in the courts being thrown in and therefore backlogging some of the cases and just the sheer availability, right, for plaintiffs to, let's say, be able to get access to their clients or to have those meetings, in-person discussions, so forth. I think it's encouraged more conversation. I'll get a call from a plaintiff's attorney for those reasons. You know, gosh, they're supposed to be due in 2 weeks. You know, no problem. Take your time. Here are the reasons why. Can I have the same amount of time? Sometimes we file them on time, but it might be, again, pick up a phone or an email to say, I can't get access to the information that's required per se, or supposed to be required in the initial disclosures. Going to need more time for that. It automatically generates, how shall I put it? There were rule parameters in terms of timing, but I think because of those parameters that were put in place, it makes each side pick up the phone or email, at least that's been my experience, to talk about whether those parameters, they're going to agree to keep them in place or extend them. And that automatically by default generates some discussion, right, about the case. And it goes back to the prior panel. I think it was Deb Lujan was bringing up great points, you know, in terms of strangely enough, the rule with more parameters and maybe restrictions, I don't think that's the right word, has almost given more control, I think, to the parties to kind of forge your own, you know, path, if you will, about how we're going to go about producing this information.
Jeannie, how about you? From the plaintiff's perspective, what have you noticed?
Well, I am reminded, hopefully she won't be upset with this quote because I think it's a great quote, but then litigator, now Judge Lisa Gleischer. I remember when she was a mentor of mine when I was a young plaintiff's attorney, when NOI, AON, you know, the statute descended like a boulder on everybody. And that's when I was a young starting out med-mal plaintiff attorney. So I have lived most of my life under that statute. She said to me, well, really, when you look at it, Jeannie, it's what good lawyers have always done anyway. Mm-hmm. Now, caveat is without all the crazy cases that, you know, if you miss a day or whatever, which is besides the point. But I think that's kind of, I agree with what Jenna's saying. I think there has been more communication. And I do a lot of work in federal court. So I'm already kind of used to the process that's laid out in these rules. I have not had a bunch of motions to compel or anything like that that I can attribute to the new rule. But here's the one thing I would say from the plaintiff standpoint is, maybe I'm wrong, but, and the defense lawyer can tell me if I am, but it seems to me like defense lawyers, particularly in med mal, who would traditionally not really answer anything, no offense to Mark Gilchrist or anybody else I had a case with before, the disclosure rules really does seem to make them, give us more stuff at the beginning, which I think is good. It's part of what I love about the federal rules. But I would also say on the back end of that, what I'm seeing more of now from the defense side, especially med-mal, is blanket objections as to proportionality. And what the heck does that mean? A lot of our cases involve death and paralysis and brain injury. So when someone says, I won't give you the cell phone because it's not in direct proportion, what do you mean? This kid's going to be in a wheelchair the rest of her life. I think it's pretty proportional. I want the cell phone, So I think lazier lawyers, I'll be blunt, tend to now they just say proportionality along with all the other blanket objections rather than really think it through. I love that the interrogatories are limited like federal court. I don't know about you, Jenna, but I have found them to be more and more useless as time has marched on because people just don't answer and judges laughing at me because depositions are much more effective anyway. And so again, federal court was ahead on this. So I think I would say overall, I like the fact that the defense seems more afraid now of breaking the rules. It seems to me that before these rules were in effect, it would be more common for the defense, no offense to my colleagues in the negligence bar, but it's easier for them then to sit back and kind of wait and see, because then whichever side is the one that has to file the motion, kind of complain, go to court, file the motion again, then get the order and all that stuff, it rewards inertia. And obviously plaintiffs always trying to push it forward and its defense often is rather not move forward. So I think just the perception that something bad is going to happen to them seems to have helped, no offense, both sides. And frankly, I think like Lisa Gleischer said so long ago, Judge Gleischer said, good lawyers do that anyway. Good lawyers talk. And they say, hey, this is going to be 8,000 documents. You really want it? Or they say, let's meet and go through this stuff together rather than hire experts to do it. That kind of stuff. So I think they're very welcome to me anyway. And just a footnote, maybe Judge Yates can address this and maybe Jenna too. I practice in some real small counties, like I'm sure most of us do on the west side. Some judges have not gotten the message that we have new rules, kind of. Anybody else? And so what's happened to me anyway, in some of the smaller counties is we just get their their form and it doesn't address any of the new rule. And it just says, do this, do that, ask your questions, tell me if you need a trial date kind of thing. And it just comes in the mail, and you're like, oh, wait a minute, there's this other stuff. And then if the disclosure issue comes up, some of them are kind of like, what disclosures, and so I'm not trying to, that it's kind of getting the word out. You know what I'm saying, right, Judge Yates?
Yes.
I'm not hopefully, but some judges are kind of wed to the original general court rules from the 80s or something, which I never practiced under. But I think overall, I would say I think it's helped. I think one of my favorite rule changes is the 7-hour limitation. As an employment lawyer in the 90s, oh my Lord, we had 8 and 9 day depositions, which were ludicrous. So maybe in the way that we all like judges who are tough on discovery when we're having our discovery, ox being gored, I think the rules are they seem to have a little more teeth, whether judges are using them or not. I can't say because I haven't had any specific motion or something where I felt like I was really testing the rule. It's starting to happen though, as cases get older. But overall, I like them. And I think they're all good policy changes, but I think we got to teach everybody they exist. That's kind of more my issue.
Judge Yates, 2 years ago about right now, we had about 300 people in a seminar and you were talking about the new court rules. And I made a couple of notes and I went back and found them and you said, what we really hope these new rules do is encourage communication between the parties. We want to be less involved as the court and get the parties more involved. You also thought that they would encourage voluntary document production like Rule 26 in the federal court, and hopefully increase efficiencies, decrease costs, and lead to quicker and better resolutions. Has it happened in your mind, even though we've been inundated with COVID for almost 2 years?
I think that the results have been somewhat mixed, and if you'll let me critique the handiwork of the committee and the Supreme Court, I'll be glad to do that. First of all, I'm going to pick up on several of the points that Jeannie made because I agree with virtually everything she said. But let me start out where she anchored her comments, and that's Chief Judge Gleicher, who coincidentally sat next to me, or I sat next to her at every single one of the committee meetings. And I can tell you that the extraordinary amount of crosstalk and discussion that went on, in addition to the main discussion, was really quite something. And to the extent that anybody would think that these rules were ill-conceived or hastily thrown together, I can tell you it's quite the opposite. Judge Gleicher was terrific at forcing us to think hard about every single thing we were doing, and that's all to the good. I went into the process with the same philosophy I've expressed at least 1,000 times from the bench, that discovery is a means to an end. It's not an end in itself. We don't do discovery for the sake of doing discovery. We do discovery for the sake of being ready to file motions for summary disposition and respond to them, and then to try the case. And as a result of that, I had 6 basic goals, which I sketched out here on a piece of paper to go over with you, to show you where I think we did well and where we came up short. My first goal: eliminate thermonuclear discovery exchanges. Failure. I have cases on my docket now where I have established beyond all possible doubt that if 2 attorneys on opposing sides of a case are determined to try to kill each other in discovery, there's not a darn thing the court rules can do to keep them from doing that. I've tried and tried and tried and tried, and I've even implored people not to lay waste to the fact that I spent 3 years of my life working on this stuff, but all to no avail. So to the extent that there are some attorneys out there who want to make discovery an all-out nuclear exchange, there's very little the new court rules do to, in the final analysis, allow judges to prevent that from happening. But let's look at the more routine cases where at least one, and often both sides, want to try to cooperate in discovery. I think that's where we've seen some successes. First of all, we wanted to increase the focus on electronically stored information discovery, because let's face it, there's still some cases where you don't have ESI, but they're few and far between. And so we tried to streamline that and make it more cost effective, because if there's one thing I've learned in the course of my career, it's if you want to spend $1 million on ESI discovery, you can do it. It's foolish, it's pointless, but you can do it if you want. And I do think that people have become much more cognizant of the ways in which ESI discovery can be managed. And so that's a success. The next point is front-loading thoughtful exchanges. And I think that's been a mixed bag. Initial disclosures in the main, I think, have been exchanged, at least in my cases, because I make a big stink out of it if people don't exchange initial disclosures. And the penalty for not making your initial disclosures is you don't get out of the starting gate. You can't conduct discovery. So all I have to do is tell somebody, look, send over your initial disclosures. Until you do, the other side don't respond to anything they say in discovery. You don't have to. That's the sanction under the court rule. Don't ask for attorney fees. I'll get to that in a second. And I do think that that's worked out pretty well. And I would agree with Jeannie's observation that a lot more information gets exchanged early on in cases than it used to. And that's all to the good. The next point is one where I want to pick up on something Jeannie said, because she really put her finger on the problem. We put in the proportionality rule in order to force attorneys to think at the beginning about how much discovery ought to be done given the nature of the case. If it's a breach of commercial lease and you're fighting over $30,000, you don't want to have an ESI expert. You don't want to do all that stuff. You just need to do some basic discovery and get where you need to get. And the whole point of proportionality was to force everybody to think about it at the front end. Unfortunately, it's just become one more club in the golf bag when you get a motion to compel and the response is not proportionate. Well, that's not what any of this was supposed to be all about. Don't get me wrong. It's a proper objection to make if the other side asks you to produce every corporate document ever generated in the history of the corporation. Of course, I'm not going to force a motion to compel. I'm not going to grant a motion to compel that, because it's wildly disproportionate to the needs of the case. But proportionality was supposed to be a front-end, broad-based consideration, not just one more weapon to take out and use to respond every time you get a motion to compel. And so if you have a case that's complex or that involves a lot of money, where really important rights are at stake, I'm not going to invoke proportionality to shut down discovery. On the other hand, if it strikes me as a simple, dumb little case, we're not fighting over a lot of money, there's no major principle at stake, by all means, I will use proportionality as a method to rein in out of control discovery. The next two, and I'll finish on these two because these are, I think, the ringing successes. First of all, the rule is supposed to make discovery from non-parties more balanced. In my experience, it used to be that non-parties just got flat run over. I mean, they never had any chance in the fight. It was never a fair fight. And now I do think, and Dan Quick, who's really the chief architect of the rules, gets a lot of credit for that, creating a separate rule dealing exclusively with discovery from non-parties and giving non-parties a chance to catch their breath, respond appropriately, and be heard. So that's been, in my estimation, one of the great successes. And then finally, and I take personal pride in this because I asked to be the one who worked on all the sanctions provisions to try to get sanctions requests down to a dull roar. I mean, if you recall the way the old rules were structured, if somebody filed a motion and the other side responded, the rule almost required the court to give attorney fees to one side or the other, which is insane. First of all, I already spend way too much of my life trying to figure out what reasonable attorney fees are under Smith versus Corey and Purdue. It's the most boring, painstaking, difficult thing you can ask a judge to do. And yet we were asked to do it all the time just because of discovery fights. And that never made any sense to me. Second, in rewriting the sanctions provisions, you'll see that judges are afforded a great deal more discretion in fashioning an appropriate sanction. It's not just attorney fees and nothing else. It's tailoring a sanction to the violation. So for example, I once had a case where the plaintiff was entitled to 25% of the net profits of the company as part of his compensation. Well, he filed a lawsuit because he thought he was dramatically undercompensated, and the defense just refused to participate in discovery. And so how's he supposed to make out his case? He has no idea what the actual net profits look like once you take all the fraudulent stuff out that was being run through the company. And so instead of awarding attorney fees, I got fed up, and at the request of a very brilliant attorney, he said, why don't you fashion this response? We just get to point to any expense, and then the burden is on the defendant to justify it as a valid part of the computation of the net profits of the firm each year. And so the way that sanctions provisions work today, if you come in with a good solution to cut the Gordian knot, a judge can do it. I mean, there's even, in addition to the general sanctions provision, there's a special subsection that says any sanction the court deems appropriate. And any sanction the court deems appropriate is an invitation to all of you to come up with a good response to somebody who is being intransigent during the discovery process. And, you know, there are plenty of people who've got more than enough money to pay attorney fees from now till the cows come home if what they're paying for and paying for attorney fees is never having to turn over the important documents in the case.
Yeah,
So
we've seen that.
I think that's worked well. I hope more judges are using it. I would say one last postscript to my comments based on what Jeannie said about judges not applying the new rules. All I can tell you was I went on my minstrel tour all over West Michigan. I went everywhere. Any place that anybody wanted to hear me, I showed up. I went to law firms that invited me. I went to bar associations. I went to judges meetings. And so we have tried our best to put the word in the street, but you know, not everybody's listening. And I wish I had a better explanation for that. We rolled out so much judicial training on this. And if there are judges who either are unaware or indifferent about the fact
And
that
in defense of the judges though too, remember the clerks run the courthouse, especially in smaller counties. So I think maybe that sometimes is where it's breaking down.
So let me drill down here.
Yeah, but in the event that you find anybody who would like any further explanation, education, explication of the rules, I've got my 3-ring binder and my handouts, and I'm still ready to travel to anybody who
Have binder will travel. Let the world know.
I
Well,
got
let's do-
handouts.
Let's drill down on a couple of things that the new court rules asked us to do or require us to do. How about discovery conferences? Anybody have any difficulty with discovery conferences? Initially, we really didn't know what that was going to be like. We thought we were going to be in early scheduling conferences. Then we thought we were going to be in discovery conferences. It seems like it's worked out pretty well. How about you, Jenna? Any problems there?
No, no problems. You know, I have in the last couple of years, you know, to me, to be, you know, blatantly honest, I have some judges, perhaps as Jeannie had referenced, that may be following the new court rules in theory, but it's kind of the same old, you know. We still get the spit out the status, you know, conference, what's called a status conference, but it's really, geez, you don't have to show up. Here's your scheduling order, like, you know,
Right.
we used to do in old days. But I do have a lot of judges who have implemented it. And again, it precipitates that conversation before your time to shine on Zoom with that particular judge. I just had one yesterday morning where, you know, relatively new case. We knew that we had a status conference that really was going to go over exactly this. What do you guys want to do? And this judge is very, and the judicial attorney, very open to, hey, we'll do whatever you guys want to do. We just want to know that you have a plan. And so obviously all of the things that we've already been discussing today on the panels were discussed. Is everybody in agreement? Do you want a case avail, or do you want to waive that and go to facilitation? If so, who do you want? How much time you think you're going to need? You know, again, the caveat of, well, with COVID, you're probably not going to have a realistic trial date until X, you know, so we really don't care what you do. Just make sure you agree amongst yourselves. Come back if there's disagreements. So for the most part, again, it's encouraged discussion ahead of time, in lieu of perhaps even the judge or the court dictating and directing where things will go. And that's again with, you know, the presumption that the parties are in agreement, which most of the time I have, which is wonderful, you know. So no, haven't had any issue with it. And at least to go back to one of Jeannie's points, look, in my experience, both sides of the fence, right, can drag their feet on a lot of things. This is one step early on that once again, I think helps get people, you know, in gear and have a plan set that before maybe we didn't, you know, or a lot of courts weren't mandated to do.
Jeannie, how about you? Any
Well, that's
problems?
kind of what I was saying is I haven't seen a big increase in judges saying, come in and talk to me because of Zoom and COVID probably. I think, again, good lawyers already try to reach out ahead of time. What I've had more of, I get form orders that are pre-filled out or not filled out. And then I got on the phone with the other lawyer, you know, we kind of put it together. Most judges are like, great, we'll do that. There are a few courts I've seen, Ottawa County is one of them, where the judges there tend to be a little more aggressive, or I know Judge Helsing is. Their scheduling orders have tightened up. They refer to the court. I mean, they're very, very proactive. Let's put it that way, you know,
They
to
saw
do.
Judge Yates' seminar, that's why.
Yeah, I'm sure it was. But again, it's like judges who were strict about discovery, their orders have embraced the new rules, I think. I haven't had anything where we had to come into chambers or we had to have a Zoom meeting and lay it all out like a Rule 16 conference, you know, nothing where judges have made us do that. It's more of us chasing the courts because they're so busy and they're all closed half the time. Sad to say. But I would say, again, I think it's a good idea. I really do wish more judges had your attitude, Judge Yates on this, and Judge Helsing for that matter, who want to be aggressive and proactive in the discovery process and be creative, like you were just saying. Because it's really hard for defense or plaintiff when you've got a discovery issue that's here and now for, you know, that minute, and you got a dep coming and the court says, oh, you can't get a hearing date for 6 months. Well, discovery's going to be over, you know? Yeah, and I think,
Whoops.
yeah.
Judge Yates, how about you? You expect to see more people or not necessarily at the discovery conference stage?
Well, for the decade that I've been running the business docket, strangely, we're coming up to the 10-year anniversary. I've been having initial case conferences in every single case all the time. Now, I have the luxury of having a lighter docket than a lot of judges, but I found it extraordinarily helpful because we're able to shape the case, we're able to shape the discovery plan, we're able to fit discovery to meet the needs of the case. And I also find it really helpful to talk to the attorneys from time to time. So what I'll do is I'll schedule a status conference every 2 or 3 months just to check in and see how people are doing. It's amazing. You know, you make attorneys touch the file, and sometimes cases just settle out of the blue because everybody picks it up and thinks, why is this case still around? I don't know. Well, let's get it resolved. So I found it helpful for a whole bunch of reasons. And I really like talking with lawyers periodically about their cases and how they're coming along.
It seems to me courts are doing that more, using Zoom under the new court rules to engage lawyers, even if it's for 15 minutes. I've had that in several of my own cases, and I do think that's an improvement that has really come about. I'm seeing everybody's head nod yes.
Yeah. Oh, yeah. And that's, again, similar to federal court experience where judges will often do that on their own.
Right, a Rule 16 status conference, you're coming in and you got to explain what's going on. How about we change to electronically stored information? When we talked about that 2 years ago, everybody trembled and was worried. We were required to have an ESI conference. Then we were required to have an ESI discovery plan. If you were the plaintiff, you had to do it within 14 days after you disclose things. Then you had to have a ESI discovery plan put together. It doesn't feel like it's been that problematic. Let's go around again. Jenna, a big problem or not?
No, and it's funny, I remember obviously at that seminar that Judge Yates spoke at, I think I did too, a couple of years ago. And you're right, everybody was concerned, like, what is this going to do? And I gotta be honest with you, I've not had this even come up, let alone one issue in any of my cases.
Right.
And, you know, I humbly say I've got cases that are small and some very, very large. Haven't had it come up at all. Why? Again, I'll go back to what Jeannie said. I think, you know, it's a matter of if you can be proactive, and that's the type of attorney you are and how you practice in terms of picking up the phone or producing things that you're supposed to produce. This never comes into play in my world. It just hasn't, you know. So in my book of business, it hasn't been an issue at all because it hasn't even, you know, popped up, so to speak, as being relevant. Probably because everybody's talking.
What about, yeah, what about audit trails in the med-mal world on the defense side? Talk to us about that.
Yeah, so, and that's kind of where I was, you know, going to go. Again, I respectfully say, if it's requested, you know, and unless there's a reason for some sort of objection to producing it, it's produced. You know, I've had one occasion, I was in trial, it was well before these court rules. I was in trial, and it was, let's see, right before closings, when the plaintiff's attorney then decided to ask for the audit trail. Clearly objected and said, well, it really can't be relevant now. That being said, yeah, you know, I don't think, at least the clients that I've dealt with across the state, I've really not had any pushback. Maybe Jeannie, you know, has had different experience, but I haven't had any pushback because it is relevant, right? You know, I mean, most of the time when you got a bazillion different providers, and frankly, it's going to help both parties out, try to figure out who the heck's involved and when, for the most part. And so it's produced.
Jeannie, how about you? Problems?
I would say this, and that is, I have not necessarily sat down in each of my med-mal cases at the inception and said, oh, I know this is a case where I'm going to want, you know, all the audit trails and I'm going to want all the metadata. I admit I have been delinquent, but the problem I think is for med-mal, and this is different, obviously, Judge Yates in the business court, but in med-mal cases at the outset, you don't always know, right? I mean, fair, Jenna, how important the electronic records are going to be. And sometimes it turns on, you know, a PA or a nurse or a medical assistant says, oh, well, there was that text I got from the doctor that said, oh my God, we're going to get sued. And you're like, what? You know, and then you're like, gee, I think I need that cell phone. But the other issue is, and I just attended a great seminar on this that MAJ put on with some national speakers, and that is, you know, now I'm sure you know this, Judge Yates, there's all these like EMR companies. Yeah, and forensic, not just med-mal, but other cases too, where you hire them basically to help you go through, right, Jenna, and find all the stuff and understand what it means. And I'm just at the point now where I have a med mal case that hasn't resolved, so I'm getting more into that whole issue. And that exact thing happened. Some witnesses, non-defendant treater witnesses said stuff, and I went, "Oh, I want that stuff," And some defense attorneys, I won't name any names, are kind of old guard, and they're like, "What is that? I never even heard of that," So they have to go to their IT person. And you remember, Jenna, when you used to have to, and probably you too, Tom, you had to always depose the IT guy at the hospital or some flunky to tell you what all the codes meant. It took forever. Well, that's kind of going away. Now it's more, I just made my first request, suggestion of a plaintiff attorney out east who does all the time, which is, I want to spend a day on your metadata for your Epic system with supervision, and I can't change anything. And I thought, you know what, that's a great idea. So we'll see how it goes. I made the request, we'll see. But if I had been really smart, like Judge Yates was saying, and proactive, I suppose I should have anticipated that and done it at the outset. But as you know, Tom, and med mal cases are expensive. So
you can
you
spend a
don't go
lot
out
of
and
money
say,
and get nothing.
yeah, right. I know I want to do all the ESI in the world, and that doesn't, I'd say it's to be avoided unless there's some issue. You know what I mean, Jenna? Like there's, back when we had fetal heart monitors and there was actual paper, like where are they and all that. Nowadays, I think you don't always know at the outset if it's important. But I haven't had any defense attorney say, no, you can't have an audit trail, when 10, 15 years ago, I sometimes heard that.
Yeah.
But
And
when I do get the objection, it's proportionality. It's going to be too expensive. It's too invasive, especially the texting phone thing. And I don't know if that's come up with you, Jenna, in your cases, but Epic has these programs now. And I know we're probably boring Judge Yates because he has new mid-mail, but Epic has all these sub-programs for texting and messaging that can be just gold in mid-mail cases for the plaintiff. So we're getting, I think, more into judges and defense attorneys and plaintiff attorneys going, oh, wow, it's not even about the cell phone. It's about this other item or this,
Right.
sub application. So
Jeannie, have you
unfortunately,
been able to agree with the other side? For example, if you want to download information off someone's phone who's key and critical to the case, that you both agreed to have a third party do that and split the fee?
yes, splitting the fee, yes, definitely. I've done that in big, like the case against the Grand Rapids Police Department and the Grand Rapids Public Schools, where you have tons of data. And again, that's federal court though, too.
Right.
And they're a little ahead of us on that stuff. But what I'm finding with med-mal defense attorneys is, generally speaking, kind of you take it a step at a time. And unless the carrier has an issue or there's some strange thing going on, if you pursue it, they will respond, but they'll start out saying proportionality. So then you have to fight. That's
Judge,
the go-to phrase.
Yeah, it is. We hear it a lot. How about ESI in terms of what comes before the court?
Well, let me say this. First of all, no matter how you feel about technology, discovery of ESI is just inevitable. Everyone texts, almost everyone emails. And so there's always a rich trove of evidence in texts and emails and the like. The second thing I'll say about it is that I'm amazed at how utterly unsophisticated some attorneys are, because you can't be unsophisticated anymore. You have to know what metadata is. You have to know what it means to mirror image an electronic device. You have to know what predictive coding is. If you don't know those things, you really don't know even the first thing about electronically stored information. And as a result of that, I'll have somebody come in and demand that they see documents in native format. The other side will look at me like, what's native format?
Yeah.
There's a reason that the Michigan rules of professional conduct have been updated to require that people maintain technological competence. I'm not a genius in this area, but I forced myself to learn it all, because you almost can't practice civil litigation anymore unless you understand all this stuff. You really can't.
You got to have it. Let's move on to initial disclosures, gang. How many times do you opt out of initial disclosures versus actually doing them? And what does that depend upon? Your level of trust with opposing counsel, the type of case. Give us some feel for what you do, Jenna.
Yeah, so I alluded to this on the front end. I've had, I would say, probably 70% of the time, we're still doing the initial disclosures, but it is not on time.
Yeah.
And this is, at least in my world, not because of my wishes or requests as the defense attorney, usually the plaintiff attorney, because again, I can empathize. I happen to live with one, as some of you know, to the fact that over the last couple of years, which by the way, Judge Yates, I was told to give a shout out to K College grads, so I have to say that. But they've had a huge issue because the courts are so backlogged, and now they've got, I'm talking about plaintiff's attorneys, all these cases, right, that need to be filed, but they know it's going to sit, and the expense of money, right? And so if they have a case that has the luxury of a longer statute, they may be waiting to file, on those, but the ones that were already in suit when COVID hit or have had to be filed, they're having to deal with that whole, facet now to the case, just no different than we are. And so in my experience, maybe it's just mine, I have a lot of plaintiffs attorneys. Again, we most of the time have a really great relationship, but where, they'll call and say, for the reasons I alluded to earlier, can I have some extra time? I'm not going to be able to get them to you in 14 days, it's of course, and usually it's okay. And we'll give you whatever time you need. So it's A, they've been working, I think. B, it's usually been gentleman's agreement, for lack of a better term, in terms of, extensions of time or deciding our own parameters of when each side respectively will file them. And C, I don't see, so far, I have not had any court, obviously, that has had any issue with it when it comes to pass, or if it's, it's irrelevant to the court, right? If everybody's like anything, if you're getting along and you're exchanging information, then the court doesn't need to get involved. So they don't care. In terms of the substance of initial disclosures, same thing. I think, just as Jeannie said, similar to, I've had, some cases in federal court through the years, not as much as Jeannie, certainly, but I like it as well, because then it's okay. Everybody's got the same rules, have to, lay out your information. And if you do have an objection to it, great, let me know. But then it on the front end. You're not pulling teeth to get the information from either side, I think. So I've welcomed it. I've welcomed that, again, for lack of a better term. I think it gives us all a little more control about, when we're going to do things. But in the same token, if a party, for whatever reason, we all have those cases, is not cooperating, is not producing things, whether by, time frame as dictated by court rules or time frame as dictated by your agreement, you still have the opportunity, no different than you did before, to file those motions if you need to. Again, thankfully, similar to Jeannie, I rarely file motions, don't need to, because usually you can have that agreement.
And how about those occasions when you do agree with the other side and you stipulate to opt out of initial disclosures? When do you do that?
In terms of when do you agree if you're gonna?
Yeah, when do you agree? If you've got a case with someone you really know, is that when you do it, or you think it's a one issue case or a one expert case? Do you ever do that strategically, or when would you entertain an invitation from opposing counsel to opt out of initial disclosures, if at all?
Yeah, great question. So in my experience, haven't really had that happen, to be honest with you. Maybe as Judge Yates indicated before, and Jeannie, maybe it's given a little bit more of a threat of this is a mandate and you must do, but
right.
Everybody's willing to work with the parameters and, skew them a little bit. Haven't really had anybody approach me, or I haven't had the situation vice versa to say, gosh, you want to scrap them altogether necessarily. We've had some form or fashion of utilizing the initial disclosures. But I agree with you, Tom, that I think depending on the case, I would be absolutely open, to saying, sure, if you want to scrap that, fine, but I think the benefit has outweighed, foregoing them altogether, because, it's information that you're going to need on pretty much any case, unless, of course, like you said, could be a case by case basis where maybe it's a case early on that, you're going to tee up for resolution. Okay, why do I need you to go through the motions? And as long as you're not going to make me go through the motions. Obviously, in my world, that doesn't happen as frequently as the plaintiff's attorneys would like. But when it does, we agree to it. So
yeah, better to get the stuff late than not at all, unless you can all agree on what the central issue in the case is.
Yeah.
Jeannie, how about you? Initial disclosures. Give us your insight. Problems,
I like them, and I've not had anyone talk with me at all about waiving it. I haven't had a case where I felt was necessary. But I did have one interesting case where, without getting into all the details, we have multiple defendants. You know, we filed the lawsuit, we got some appearances, and then we didn't see the answer. And then we filed our initial disclosures, and whoops, the defense lawyer was like, oh, I forgot about that. And then it was like scramble, motion, whatever.
Right.
That was kind of interesting, but it wasn't on purpose or anything. It just kind
They
of
missed
happened.
the seminar. That's the problem. They missed the seminar.
Well, it was funny that the initial disclosure rule reminded them they had to file an answer. That's basically
Yeah.
what happened, which was kind of mind blowing, but anyway.
You know, initially, a lot of us thought that maybe everybody would opt out of them and they wouldn't be used much at all. But it really hasn't turned out that way. I agree with you, both of you. In my practice, almost every case, we do have initial disclosures with the caveat that oftentimes it's modified. Instead of 14 days, 30 days. Just like.
Right, exactly.
you
Just
were
like
talking.
sort of the normal way we do normal stuff, right?
Judge, how about you? Initial disclosures, people complaining, filing motions, are they mad? Are they happy?
First of all, it was heartwarming for me to listen to Jenna's answer, because that's exactly what I hoped was going to happen.
Yeah.
And as a result of that, I'm very pleased that the initial disclosure provisions are pretty ironclad, and yet they don't have attorney fee sanctions. They just say you can't do discovery if you don't do your disclosures.
Way
It's not
better.
supposed to be, right. It's not
It's
supposed to
way
be
better.
preclusive
Way
or
better.
anything.
Yeah.
The other thing that I would say about initial disclosures is that any idea survives on the basis of its utility, not whether it's a straitjacket. And I think initial disclosures are doing well because there is real utility in them.
Yeah.
You remember years ago when the court rule came down that, among other things, said that during a jury trial, the judge could sum up the evidence in the middle of the trial for the jurors, and nobody did it because we all thought that's the dumbest idea we've ever heard in our lives. Whoever wrote that obviously has never tried a case as a lawyer or a judge. And so it just fell by the wayside and everybody just agreed to
Nobody ever
ignore
did
it.
it, right?
So stupid. On the other hand, something like initial disclosures serve a real purpose in getting information in the other side's hands early enough so you can start to have a meaningful discussion about where you're headed. So I can't tell you how pleased I am with how well that part of this has turned out.
Yeah. So let's go to proportionality for a minute. That's MCR 2.302B1. And it was scary at first. We all thought that there's no way anybody's going to produce anything. It has produced motions. We've all got a brief now on our respective computers that talks about proportionality and talks about the 8 or 10 things that people are supposed to look at. Has it helped? Has it hurt from the practitioner standpoint? Jenna, what do you think?
Yeah, I haven't had to deal with this again that much, to be honest with you, because maybe I'm just lucky. I don't know. And maybe I'm too easy a target. I don't know. And I turn stuff over, but you know, I don't know. Yeah.
Good for you, actually.
Yeah,
That's right.
You know, to me, it's like, why, why fight if
Inevitable, right? Yeah.
Yeah, sorry. I mean, and maybe I'm the rare bird. I don't know. But no, I don't think I really haven't had to. I haven't, had to use it, and I haven't, had a plaintiff attorney have to use it for something that I've requested. So, at least in my experience thus far, I think it's there. As Judge Yates had mentioned before, whether you want to call it a club in the bag, I hate to use the word weapon, but a tool that can be used when and if necessary. But at least in my practice, all different plaintiffs' attorneys across the state, so on and so forth, he hasn't had to be implemented, perhaps because you just haven't had the situation, where it's such an egregious request or something of that nature where you have to use it. But I guess I'm glad that it's there if necessary as a tool.
I should remind the audience, in case you haven't bumped into it, it states basically when you're fighting over whether or not the other side can have whatever you're asking for, the test now is whether the burden or the expense of the proposed discovery outweighs its likely benefit. and the complexity of the case, the importance of the issues at stake in the action, the amount in controversy, which scared us all, I think, at first, and the parties' resources and access to relevant information. When we first read that 2 years ago, Judge, we all trembled. And
Yep.
you said, don't worry, we're going to get through this. And you took us by the hand and have helped us along. Jeannie, how about you? Before we go to the judge, what have you experienced on this proportionality burden? And we look at things like the importance of what's at stake.
I have not had a motion that I've had to argue on this precise issue yet. I have a couple that might be coming down the pike in some med mal cases, which is why I was kind of curious to know if it had come up with Judge Yates in his caseload, because I know in business discovery, there's always fights over documents, always. But what I was going to also say is that the issue about parties' resources and access to relevant information, I wasn't on the committee, so I don't know where all the language came from. I know some of it mirrors federal case law that's already out there from federal rules.
Yeah, it does.
But one of the things that I've experienced before the new court rule, so I don't have a chance to test it yet, is that there were some judges under the old rule that were very absolutist, kind of like, hey, it's a big case, so you're going to get whatever. I don't care what the costs are, which I don't think is useful. But if you represent individuals, like plaintiff lawyers mostly do, it can be impossible, right, for some people to be, and I'm sure Judge Yates sees that in small business versus big business, but they can't afford, nor to even know how to go back and get all the ESI or whatever it might be. So I think the language is appropriate, meaning the elements, I think, would have to matter. But I am finding it, it's my bugaboo now, is that word, proportionality. I just don't like it because I find it, unfortunately, is used often just as a lazy way of saying, I don't want to give it to you.
Yeah.
And then when you try to meet with the attorney or we have Zoom calls, they're like, well, it's so expensive. Well, it's so, well, if it's a giant legal malpractice case worth hundreds of millions against a huge silk stocking firm, the judge is going to let me have it. If it's a small slip and fall against Meyer, we probably aren't going to get every tape from the last 6 years.
Judge, we're running out of time, but give us your thoughts on proportionality. How's it played out from the bench?
Yeah, thanks, Tom. I had a lot to say about proportionality earlier, so I won't say very much about it now in the interest of time and in the interest of not being repetitive. But let me just offer a couple of thoughts. First of all, the way Jeannie explained it, I think is about right. If you have a good reason that you want something, tell the judge. And if it sounds like a good reason to the judge, you're going to get it because that clearly will pass any proportionality test that's out there. Second thing that I would offer as a practice pointer is one of the difficulties with discovery is that the costs are asymmetrical. In other words, with a very little amount of effort, you can impose enormous costs on the party that receives your discovery requests. And it's even worse in ESI. And what I've told people when they want to dig out every last text message or whatever the case may be, search the unallocated space, whatever, I've always said, it seems prohibitively expensive, but if you're willing to pay for it, sure, let's do it. Don't impose the cost on the other side. I mean, if you really want something and you really know you want it, tell the judge and we'll pay for it. Because that makes a world of difference to me. That's all I have to say about proportionality.
Let's talk real quickly, gang, about three things. You touched on it earlier, interrogatories. We've got 20 interrogatories. They are the Scud missile of litigation. They rarely hit anything. We all know that. There's document production, which is where we mine our gold. And then there's depositions, which have a 7-hour limit on them now. Helped, hurt? What do you think? Jenna?
Helped all the way. Interrogatories, agree again with Jeannie, and I believe Judge Yates said as well, similar to federal rules, hence why they were created. It makes you hone it, and I'm sure the plaintiff's attorneys in particular have been ecstatic about not getting all of the stupid page after page interrogatories, form interrogatories from defense attorneys, associates, so on and so forth. So I think it's really helped because then, people are getting older, you have to make sure you're teaching those younger attorneys, right? That you have to focus and hone those questions and why they become important a year down the road for trial. Whereas before it was just blanket, ad nauseum things. So I think that's greatly helped. Depositions, I've only had a few plaintiffs' attorneys in my 25-year career almost that have taken longer than 7-hour depositions. Most people, I think, that are good attorneys can get to the point within a couple hours. So I haven't had it per se apply in the last couple of years, unless you happen to have a case with a couple particular plaintiffs' attorneys. But I think it's a good
attorneys for that matter.
Yeah, that's true. That's true too. That's true too. And I think it's good. I think it's really helped. And just in terms of document production, same thing. If we're going to have to give up the goat at some point, then either give it up right at the start or give a valid objection. And then if we've got to fight about it, fine, but it's not languishing for months on end. And that way, you both can move forward. So overall, all of those facets of the new court rules, I think, have been overwhelmingly helpful.
Wonderful. Jeannie?
Yeah, I think they've all been good. And again, I think smart lawyers didn't waste time on 100 interrogs with 42 subparts anyway, because they get you nowhere. I like the Scud missile idea. And I think the request to produce is where the meat of it is anyway. And I also want to comment with Judge Yates's comments about third-party discovery, as it were. I think it's great to do it the way we're doing it now, instead of the old subpoena that said, give me everything within 10 days. And the little clerk at the store is like, I don't know, what is this? I'm so afraid.
This is a traffic ticket? What is this?
Yeah, right. So I think that helped a great deal as well. On the request to admit, though, because you didn't touch on that, the only thing I would say is we're using them. We've always used them a lot. And we're trying to use them more, but I don't know yet because I haven't seen judges rule on it. Is that something anybody can comment on? Because I'd like to know, is the new version of the rule actually got teeth or no?
I know. Judge, I'll leave you with our last thoughts, your last thoughts.
I have two short points to make, and the second one is exactly what Jeannie just asked about. The first point is with regard to the 7-hour limit on depositions. A lot of people ask, so what happens if the deponent shows up and doesn't bring any of the documents the deponent was supposed to bring? What do we do? My view of that has been get as much done as you can, then stop the clock, then I'll let you go on a second day. I would be really upset if there were other judges who weren't doing it that way because it's 1 day, 7 hours. My view about that is, yeah, but if the deponent doesn't bring the documents, you still get to have your time with the documents in hand. The second point I want to make, which is exactly what Jeannie was anticipating, is there aren't a lot of attorneys who do this, but I am so sick of this trick where since there's a limit on interrogatories, but not on request to admit, somebody will propound 386 requests to admit. And then interrogatory number one will be, if you answered no to any request to admit, identify it and explain why, which is like 386 interrogatories.
Only in the business world, Judge, only in the business
right.
world.
No, I mean, and I have no problems with 386 requests to admit if that's what you want to do, but don't tie it back into one interrogatory so it becomes this exploding interrogatory with 386 parts to it.
Gang, I want to thank all of you. The hour is late and I want to be respectful of people's time. We've gone over a few minutes. So thank you all tremendously. This has been very helpful, very enlightening. We'll have to do it again in a year and see how things have progressed. I'm going to turn it back over to our chair, Bob Riley. Bob?
Thanks, Tom, and thanks to all of the individuals who volunteered time to speak today. Frankly, I can't thank you enough, and the intensity of the preparation is obvious, and the commentary that you provided is outstanding. Thank you. We're now available for questions. I apologize to Judge Yates. I'm not sure what a cell phone is, much less other technologies. And accordingly, as we take your questions through the chat room, bear with us as we attempt to answer your questions. Of course, the hour is late, and if there aren't very many questions, this is a group that you can feel free to reach out to. The Negligence Section Executive Council takes these matters very seriously and wants to respond to those of you who attended this session or have issues, concerns, or the like you'd like to share with us. Chad, are you monitoring questions and the like?
Yeah, we've been going through the chat as we speak. I think we just had one come in, but otherwise we've endeavored to answer them as they've come in. Actually, Ken Watkins from Summer Schwartz didn't have a question. It was just a very nice comment. He says, very nice discussion by both panels, very helpful. The other questions dealt with the retroactivity of the rules, which was addressed and very, very eloquently by Judge Yates. So let me just say thank you all for participating in this panel and this webinar. The educational component of what we do at the negligence law section has grown exponentially in importance over the years, and it's only because of the excellent speakers that we have, and also due to the administrative support we get from shared resources, Matt Hinkle and Madeline Lowry. Thank you all very much, and I hope everyone has a great weekend.
Thank you very
Well-
much, Chad, for all that you do.
Thanks, everybody.
Thanks so much.
Everybody.
So, let me close and say thanks to all of you for attending, and we'll look forward to seeing you again in negligence section programs down the road.
Thank you.
Everybody be well.
Bye-bye. Have a good weekend.
Bye.